more importantly, I've got a news story from you about a very well-known person in the gun rights community, Dick Heller. What is he up to right now?
That's right. Dick Heller is back in the news for more gun-related litigation in the District of Columbia. He just had some success once again getting the district to repeal a gun law that he was challenging in court. This time it's sort of a peculiar law that I don't think a lot of people outside of DC are kind of aware of. But since the mid-'70s, DC has had a restriction on the amount of ammunition people can carry if they're licensed to carry in the district. So this isn't a magazine capacity restriction. They have one of those as well. But this specifically refers to the amount of ammunition you can carry on your person when you're out and about. So their previous rule was it could only be twice the amount of the capacity of the particular gun that you're carrying. So say you have a 6-shot revolver that you're carrying. That means you can only have 12 rounds of ammunition on your person. And the maximum cap is 20 because they have a 10-round magazine limit. So they assume that you can't carry more than 20 rounds of ammunition.
And it's unique to every individual person's gun, right? It's one of the real odd things about it, because the same person could have two different limits based on whatever gun they happen to be carrying.
Right.
But yeah, so Heller challenged that, right?
That's right. Yeah. Very shortly after the Bruin decision got handed down in June, he filed a suit against DC, and that just 2 days before they were set to file their reply brief to his complaint, basically defending their law against his request for an injunction, they just decided on an emergency basis to outright repeal that law just to avoid the whole thing. So he was successful once again in getting them to repeal a gun law.
Yeah. And for those who don't know who Dick Heller is, he was the individual plaintiff in DC versus Heller, which was the first time that the Supreme Court established the Second Amendment protects an individual right to own guns, to at least keep guns inside your home. He was challenging at the time DC's total ban on the ownership of handguns, even inside your own house. So he's very important in Second Amendment litigation for that reason. And he's also pretty unique. And you talked to him, so you got some idea of this. He's a very passionate, he's kind of a gadfly, right? Which is a little different than what you find with a lot of individual plaintiffs in federal gun cases, because usually the way it works is, a gun rights group wants to challenge this law. They think they have a good shot at overturning it. And so they go out and recruit plaintiffs who are affected by it. And these people are, people who want to see the law overturned because it adversely affects them personally. But, and you need you need individual plaintiffs in often cases to have standing so you can actually sue. Usually it can't just be the gun rights group on its own. They have to show there are people affected by this individually. But in that case, in most cases, they're recruited by these groups. They go out and try to find somebody who's willing to sign on to a lawsuit. There are occasions, and Heller is probably the most well-known occasion of this, and at least in the gun sphere, where you have a plaintiff who initiates a case on their own, who's sort of more of an activist litigant. Like they're involved from the very beginning. They're the ones who want to bring the suit, and might even face either opposition. I think Heller faced quite a bit of opposition from the gun groups to filing his first case. Some people didn't think that was going to succeed, but he went forward. Alan Gurrow was the lawyer who won that case. And you also have occasions where perhaps a litigant who's not a plaintiff, who's not in an area that's very popular for gun suits. So Hawaii in particular, and I'm thinking of George Young, who is the plaintiff in Young v. Hawaii, obviously. But that case made it all the way up to the Supreme Court and was granted, vacated, and remanded in the wake of Bruin. But it was the open carry case against Hawaii, and that was filed by Young on a pro se basis initially, which means without a lawyer. And he had tried to file against this law a couple of times and was having what Alan Beck, who ended up being his lawyer, felt was he was being treated unfairly by the court system. And so Beck wanted to help him just to be able to make sure he had everything in line to get this case an actual, hearing in front of a judge, not necessarily expecting it to turn into a major gun rights case. But, they're Young and Heller are relatively uncommon types of plaintiffs in these cases. And Heller especially, because not only did he do the first Heller case, which turned into a landmark case, he's done, I don't know, it's 7 or 8. It's hard to keep track at this point because he's just constantly filing these cases, and a lot of them he's winning. And even ones where he loses, I believe it was Heller 2 is what it's called. That was the case against DC's assault weapons ban years ago, where Kavanaugh, who's currently a Supreme Court justice, was the dissenting vote in that decision on the DC circuit. And that was an extremely important dissent in the realm of gun litigation, because that was the first one to talk about this history and tradition standard, text, history, tradition. I think they kind of shortened it to text and tradition in Bruin, but that standard was really first articulated in Heller 2. It might have been Heller 3. Don't hold me to the number.
It was Heller 2. Yeah.
But yeah, I thought that's good. I thought that's what it was. But anyway, even when he loses, oftentimes these cases have significant impact on gun litigation moving forward. And so, he, as of late, he hasn't been losing, right? There was another recent case that you wrote about a little while back that involved Heller too, right?
That's right. Yeah. So the strategy seems to be for the last couple of Heller suits where he's gone after the district, rather than actually wait for a court ruling saying, this law is unconstitutional, we're going to put an injunction on the law, blah, blah, blah. It seems the district's new strategy is just to say, kind of read the tea leaves, see that they're probably going to lose, and then they just get in front of it and they repeal the law before any judgment can be issued against it. So the case you're referring to, we covered last year. Heller went after their so-called ghost gun ban, which again was another really peculiar law in the way it was written. It was very, very expansive to the point where there was actual law enforcement critics of the law who said, hey, this possibly criminalizes our Glocks, because they went after the whole polymer. It can't be some percentage plastic because they were worried that metal detectors wouldn't be able to detect it. It's kind of the classic hysteria that we've seen since the advent of polymer framed striker fired guns. This has come up from time to time, but essentially that's how broad their law was written in an attempt to go after ghost guns. And the attorney general actually stepped in that case and said, yeah, we're probably going to lose. So I want the city council to, amend this law just to get in front of a judgment. So, and that's basically the same thing that happened here in this ammunition ban case, where 2 days before they were expected to submit a brief defending the legality of this law under the new Second Amendment standard, they just said, to heck with it, just on an emergency basis, we're just going to repeal it. And so that's the new tact they appear to be taking.
Yeah, and it's really it's not super new for DC, because they've been doing this not just in Heller cases as well, but also in a number of major gun litigation events where, for instance, Wren v. DC, which is the case where the city's gun carry law was struck down. They had a total ban on concealed carry that got struck down, and open carry. So all forms of legal gun carry that was struck down. Then they passed what was basically the same law as what New York and Maryland and California had, which was a May issue law that basically still allowed them to subjectively deny permits to people who applied. And so they did that, and they denied almost all of them, right? And so they lost on that law as well. They had their May issue law struck down a couple years before Bruin was handed down, obviously this year. And so they had the choice to appeal to the Supreme Court, but instead they decided not to. And the Attorney General, Racine, explicitly said the decision was made so as not to risk setting a nationwide precedent. And it seems like that's why they're caving on a lot of these things. And, that's a totally different strategy than what we've seen from California and New York. In California and New York, in reaction to Bruin, instead of playing it safe or, trying to mitigate cases against them, trying to, give on smaller areas of concern so they don't have to litigate these things all the way to the Supreme Court, they're doubling down on these kinds of laws. And frankly, their strategy seems very likely to produce more Bruins, whereas DC is trying to avoid that, is what the tactic seems to be. Now, this case, it's a really weird law that it probably has never actually been enforced in any meaningful way, I would guess, because it's like very hard to imagine a scenario where somebody is arrested over this. But and so maybe DC just decided it's not worth fighting over at all because it's kind of a dumb law. But with this very random restriction. But I really feel like at this point they should probably just consult with Heller before they pass these regulations, or like talk to him about what he plans to challenge next, so they can address it before spending a bunch of money in court to ultimately lose anyway at the pace that they're going. So it's interesting to see Heller just continue this winning streak without even much resistance from DC anymore. Like they didn't even file much more realistic
a defense brief this time. Yeah.
Yeah. I mean, they just seem much more realistic about the odds of them winning on these novel restrictions that are not historically grounded.
Right.
Especially in the wake of Bruin. I mean, DC was being fairly cautious about fighting these cases up the chain in federal courts from, probably it was like 2018, I believe, was Wren. And so it's been a strategy that's kept them from having precedents, created through their cases at the Supreme Court. So it's working in that sense for sure. And I think it's more savvy, I guess, litigation strategy than what New York and California are doing, which is just blatantly violate what's in Bruin, and I don't know, hope for the best.
I was going to say it's savvy on their part, but New York and California may yet force their hand depending on how far those cases work their way up.
Right. So if it doesn't really work if half the gun control movement is taking a cautious approach, trying to minimize the rulings that are potentially going to be handed down against them and create precedents across the country. And the other half is just doing a Leroy Jenkins strategy of just YOLOing everything.
Great reference.
Doubling down on all the stuff they said. The Supreme Court, in a lot of cases, explicitly noted is not constitutional.